So hello everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law and other things, and this is our FE1 March 2025 recap. Today we're doing equity law, we're taking a look at it. So whether you're just sitting this exam or you just want to deep dive into trusts and equity and everything in between, you're in the right place. So if you want to follow me along on Instagram, it's at LawHeroIRL. And my website is lawhero.eu. I'm going to go through all 8 questions from the equity law paper and kind of give you my feedback, because that's what I do. Been doing it for a very long time. So the first one is around a donatio mortis causa. It's a classic gift on death scenario. So Deirdre says to her niece, here are the deeds, this will be all yours when I'm gone. And she hands her the documents, and now Mary is claiming the house, but Deirdre's will leaves everything to an animal charity. So we call this a DMC, a type of deathbed gift. And remember that equity allows imperfect gifts to be perfected where the gift is in contemplation of death, it's conditional on death actually occurring, and the donor parts with their dominion over the property, like handing over the deeds. That's always an indicator that they, are indicating that they want to hand over dominion. So you would use King v Dubray, Valley v Birchwood, Sen v Headley, and Naylor v Marr for estoppel overlap if you wanted to. Was this enough to override the will? Maybe not, but there's room for argument, and that's what the question is asking. Question 2 also covered, that kind of certainties. So we have 3 certainties, intention, subject matter, and objects. This one looked at certainty of objects and asked you to pick one other, either the subject matter or the intention. So certainty of objects relates to whether we can identify the beneficiaries of a trust. If it's a fixed trust, you need to complete the list test as of IRC v Broadway Cottages. If it's discretionary, is it or is it not? B McPhail, B Dalton. Ireland tends to go for a stricter list rule. For certainty the intention, Re Adams and Kensington Vestry, or subject matter would be Hunter v Moss and Re London Wine. This is a really important doctrine because if the certainty fails, the trust ultimately fails. Question 3 was a tracing and mixed funds question. This has been asked before in the context of a solicitor who mixes funds in his personal account, his own client money, and then trust money, and he then dies insolvent and one of his clients wants to be paid. So the beneficiaries of the trust also want to be paid. So it's tracing and breach of fiduciary duty. So you're dealing with common law and equitable tracing and the rules of mixing, especially where some of the funds have already been dissipated. So we'll be looking at cases like Re Hallett's estate, Re Otway, Foskett v McKeown, Clayton's case as well, and the pari passu approach from Barlow Cloves. You'd also need to set out George's rights, probably would be an equitable lien or charge, and contrast them with the beneficiary's rights under the trust, and explain why the court will favour restitution and will try to give effect to the best claim if tracing is still possible. Question 4 was Mareva injunction. I believe it was an essay. So just so know, a Mareva injunction is a freezing order, stops a defendant from dissipating assets before trial, and the quote here comes from O'Mahony v Horgan. It's a powerful, but it can be dangerous if it's used incorrectly. So this is a discussion question basically around the Mareva injunction, because the courts must protect the plaintiff's interests but also avoid infringing the defendant's rights unfairly. So what you would talk about is the requirements for a Mareva injunction, like a good arguable case, risk of dissipation of assets within the jurisdiction, then go into the procedural safeguards like full and frank disclosure, undertakings and damages, and time limits. Then you would talk about case law from Ireland and England like O'Mahony, Irish Shell v Ellen Motors, Cardile v LED Builders from Australia as well. And the trick is to show that equity is cautious and always wary of abuse, like we've learned before in our equitable maxims. Question 5 was a classic charitable trust question, problem question where Michael leaves bequests for sport in rural communities, local playing fields, and a campaign to criminalise bad behaviour. on the pitch. So you have to decipher what qualifies as a charitable trust or not. So the first one, promoting sport in rural areas, that might be valid under the head of advancement of education or public welfare, but it depends on the level of organisation and public benefit. So use Re-Nottage and IRC v Badley. The second gift is more specific, providing playing fields in a town. That's definitely public interest. But the third, lobbying for law reform, this is definitely something with a political purpose, which cannot be charitable, and that's as per McGovern v AG. Then question 6 is around Strong v Bird, rectification and unincorporated associations. You had to pick 2 out of the 3 and discuss them. So obviously we do Strong v Bird when we talk about perfecting an imperfect gift, when the donee becomes the donor's executor, and it's important that you have conditions such as intention to make a gift, the intention persists until death, and appointment of an executor. Rectification is an equitable remedy that allows courts to rewrite a document where there's a unilateral mistake and the other party knew or ought to have known, like Jocelyn v Nissan or Fowler v Fowler. Now, dissolution of unincorporated associations, I don't really do those in my ebook, but if you've done it before, good for you. These are very theory heavy, you really have to know your stuff. So question 7 was looking at trustee duties. So one of the biggest is to invest prudently, and you need to look at the standard of care, which is often referred to as the prudent business person test. Trustees must balance risk, income and capital preservation. And this comes from Stacey v Branch. Other cases you would look at then is Nestle v NatWest, Bartlett v Barclays Bank for professional trustees. Of course, you'd have to mention your 1893 Act. It's really old, but it still applies to trusts and how you should behave. And speculative investments aren't banned, but they must be approached very cautiously. The last one then is around proprietary estoppel. Again, a classic question. So Connor moved home, he invested in his father's farm and assumed he'd inherit it, or at least get some of it. Now his ex, Aoife, is claiming a share of that interest. And so we have to look at A or D. Was there assurance? Was there a reliance? And was there a detriment made because of the assurance and reliance on what was said by the donor? So we would look at Turner v Major, Gillette v Holt, Davis v Davies, McCarran v Guinness, classic. And we would apply the modern test, which is it unconscionable to deny the claim? And of course, if Connor succeeds, the court might award him a beneficial interest, but there is no strict rules. You know, the whole point of equity is to prevent injustice. Tom may argue there was no express assurance, but equity can infer an insurance from long-standing conduct, especially where money was spent in reliance. So that is literally a whistle-stop tour of the FE1 Equity. I would say that was a fine equity paper. It touched on a lot of the curriculum. I think anyone who had my ebook would have been well able to manage. If you found this helpful, please give a like and tell your friends. And remember, you don't need to be perfect, you just need to be persistent when it comes to the FE1. And of course, I will see you in the next one.